have tried to keep this class really simple and really practical. So we do all the time those things that the parents tell us are important for them. You know, those things that they felt worked. So that's one of them. So that's the purpose of the survey. The reason a couple of you who were working very hard ahead of time said, can I hand this to you now? I'd really kind of like you to keep it tonight, because this afternoon, until the end, just in case other things hit your brain. You know, sometimes you can't remember things right away until something else comes into your head. So feel free, you know, to jot stuff all over there. So that's the purpose of this. And this also includes in here all the information that we're going to go over, you know, and it's also in the PowerPoint. In addition, on the cover sheet is pretty much what I'm going to be talking about now. So, just to move. Here it is. The intent of the program is that it be informative and practical and supportive and direct you. You know, if you're looking for other resources, we can only do triage here. We can only scratch the surface, you know, of what you really need. So, you know, there's no way that in 2 afternoons, 2 hours apiece, that we can give you everything that you're ever going to need. 2 sessions, and each one's 2 hours. The first one we're going to talk about introduction to the whole process, and we're going to need to talk about mediation. The reason I can tell you that we need to talk about mediation is because as you were walking in, I'm seeing many orders that are also mediation orders. So I know that that's going to be one of the issues that you need to talk about. Some legal information. The first day is primarily legal information. What is this process? How does it work? What is custody? What is placement? To try, you know, help you gain some knowledge so you can make educated and informed decisions for your family. And then talk about the placement worksheet. Then the second session is really geared to the children, you know, and their needs. Be able to take what you've told me. We'll look at some current research. What does the research indicate about children? What are some of the common issues? Things that you guys all had in common, and things that since we've been doing this class since 1993, every single time these same issues surface. You know, so we can share some of that stuff with you. And then talk about the developmental needs of the children that you have. You know, where are they? You know, in that structure. You know, what are some of the things you might be seeing, and how can you address them? So that's what we're going to be doing. We'll try and take a break about halfway through, so you can get up and stretch your legs. I know it's not easy to, you know, just to be sitting here, you know, and listening for that period of time. And then you'll be out of here right at 5 because they shut the courthouse down. So in case you're wondering, that's like the duration of your punishment here. Now here's the big thing. You must have a custody and placement agreement signed by both parents, by both parties, and filed with the court. That's the bottom line that you have to have done. Now there's a number of ways you can do it. There's 3 ways right here. You can meet with the other party. Write it up, sign it, file it. One of the things that I'm going to tell you is, and I believe this so sincerely, is that you are the only 2 people who know how things really work between you. And you are the only 2 people who really should be making these decisions. You're the only 2 people who are going to care this much about what happens. And no one else really knows. So I think you're the only ones who can really evaluate what process is going to work even for you through this. If you guys can sit down and do this on your own, great. That's terrific. But you may want to weigh some of the pluses and minuses. And everything has a plus and a minus. Now in this, if you sit down with the other parent, the pluses are, this is by far the simplest way to do it. Sets a pattern for doing this in the future. There's going to be a lot of things that happen with your children over their lifetime for which you and the other parent are going to need to sit down and figure out, what are we going to do about this? Now, here's some bad news. This isn't over when your children are 18. This continues for the rest of their lives. If some of you have older children, you know that. You know, being a parent just doesn't stop the morning they turn 18. And you're going to need to deal with this other parent for the rest of your children's lives. So you need to figure out how that's going to work, how you're going to do that. Another reason that this might, you know, be perhaps could be your best option would be that it's by far the cheapest. You're not paying anyone to do this for you. You're sitting there, you're doing it yourselves. There you go. You have total control over what goes into the agreement because you're writing it up yourselves. Some of the negatives. might be, maybe it's difficult for you right now to be sitting down with the other parent and hammering this out. Maybe this is a high conflict time. You're just not doing well. You know, every relationship has its ups and downs, regardless of whether or not you're together or apart. You know, even professional relationships have their ups and downs. And sometimes you're getting along better and sometimes you're getting along worse. Maybe this is one of those down times and it's just hard for you to sit down with the other parent, period. Maybe it's difficult, maybe one of the parents kind of feels that the other parent is domineering. Maybe the other parent is not quite as articulate, can't get everything out in words, just can't wrap his or her tongue around it, you know, and get it out there. Maybe you're the kind of person that everything makes sense when you're sitting there, and then it's an hour and a half later as you're putting the towels away. You know, you think, oh my gosh, why didn't I say this? You know, and then you think, oh, the opportunity's lost. It may also be that perhaps you're intimidated by how to write it up in the legal fashion. I'm not saying you can't, but you know your comfort level with writing. So there's some pluses and minuses. The second way would be for you to meet with the other party and both your attorneys to write it up. Positives about that, your attorneys are working for you. You should be able to arrange it at a convenient time for you. They are your advocates, so if one of you feels like you can't get the words out that you want, that attorney should be able to speak up for you. The attorney should be able to write it up in the legal fashion. Now, some of the negatives might be, now you've got to consider not just 2 people at that table negotiating this, but 4. There are some attorneys that you want with you in that courtroom because they're the bulldog that's going to come in and in your interest rip the throat out of the party that's attacking you. But that may or may not be the best personality for sitting down at a table figuring out what's going to work. I'm not anti-attorney. I think attorneys are great to be advocates for you, but I'm saying you need to consider the personalities as well. Now, because now you've got 4 personalities, not just the 2. One of the big negatives that people mention all the time is the cost. And if you talk about the horseshoe, the billing horseshoe, I can't walk backwards for this, so here we go. Imagine a big horseshoe. And at either end you've got mom and dad. And we've got little Billy. And it's Wisconsin, where it could be 50 degrees or it could be minus 12. And yesterday it was 50 degrees and Billy was with dad. Now today he's with mom and it's minus 12. Dad is worried that mom is not going to be sending Billy with his sub-zero gear, okay, to school. That she's going to send him with his spring 50-degree jacket. But they know you can't. We're not. Don't you talk to me. You talk to my attorney. I'm not talking to you anymore. I'm not going through this. Okay, fine. Now you know about billing. Attorneys bill in increments of an hour, usually in 10 minutes or 15-minute increments. You would know what it is for your attorney, and you know what your attorneys charge per hour. So, and that is if you make a phone call, and you're on the phone for 5 minutes, that's a 10-minute chunk. Okay, so you've got that stuff. Now, as you're doing that, so you've got dad here, and dad is saying, well, okay, she's got to send him with that sub-zero gear. So dad calls dad's attorney. Dad's attorney says, sure, I'll deliver the message. Dad's attorney can't call mom. That's not ethical. Dad's attorney calls mom's attorney. Mom's attorney calls mom. Mom says, well, of course I am, no problem. Mom's attorney calls dad's attorney, and dad's attorney calls dad. Now, you've got 1, 2, 3 increments of an hour going this way, and then 4, 5 going back here. But when mom's attorney and dad's attorney are talking, they're each billing. So you've actually got, duplicates. So you've got 6, 7 increments of an hour that you're paying for. And you may say, well, yeah, well, no, they're not both paying. I don't care what you're saying about that. Here's what I'm seeing. You're right. It's not that mom is paying 7 increments of an hour and dad is paying it. Billy is. That's 7 increments of an hour's time, and money that Billy's never gonna see. So, there you go, all that for a message. Imagine if it's something even more complicated like an agreement, where you're going back and forth time and time again. You've got multiple copies, drafts, what do you think, what do you that think? You've got, typing fees, you've got all that stuff going on. Okay, so there you go, and you're really running this bill up. So the cost, obviously, is a huge factor. The other thing is this: we have excellent family law attorneys, in this county, in this state. We have excellent judges who may still write up agreements with things like reasonable visitation and reasonable notice in them. Do any of you have an agreement, an old agreement? You're in for a revision and you've got that? It's the kiss of death, isn't it? Because what's reasonable to one is not always reasonable to another. That does not mean that you have a bad attorney. That's common practice everywhere. Now, the reason you probably had it in, and I'm taking a guess, it's not that I'm clairvoyant, was that you felt like you wanted some flexibility, because gosh, we really don't know exactly what's going to work. We want some flexibility. Here's what you want instead of that. You want in your agreement, unless otherwise agreed upon. Very key language, because what that means is that in the best of all worlds, we talk about it, we agree, this is what we're going to do this week, this is what's going to work, this is my schedule, this is the kids, great, this is what we do. But if you can't agree on it, what you have written in your agreement, Thursday from 4 p.m. until Friday at 9:22, that's what your fallback plan is, and that's what you go back to, unless otherwise agreed upon. That's the kind of thing that you want. And that doesn't mean that these are bad attorneys. This is just common practice. And by the way, there is no such thing as visitation in the state of Wisconsin for parents, it's placement. The state legislature spent a long time choosing the appropriate word in the belief that children do not visit their parents. They are placed in their parents' care. The parents have rights and responsibilities when the children are with them, and they take that very seriously. Now the third way that you can get a custody placement agreement written up, and that's mediation. And that's what I'm going to talk about. This is a little difficult to read. One of the things you need to understand is that if you cannot reach an agreement and file it with the courts, then the states, which is the courts, will take over. And they will take over your family, and they will figure out what they believe is the best thing to do. Now, if you've been ordered to mediation, you probably already know it. Then, in that case, this is what you need to do. You need to, and you still have a chance to do this even if you've been ordered. You can file a custody placement agreement with the courts on your own. You can still step in and say, hey, let's just sit down and do this before we mediate. No problem. Then you don't have to come to mediation. It's not a problem. Or you can meet with the other parent and the mediator and develop an agreement to be filed by the mediator. Or you can meet with the mediator. If you've been ordered, you must go. You have no choice. It's a court order. You must go at least once. You can meet that once, terminate mediation, and then you go into the court system, to the state, for the state to make that decision. And you will pay a home study fee down payment, a guardian ad litem down payment, and then the judge will make all those decisions. Now, this is the website that contains on it access to a number of the forms that you may need. And this is on your cover sheet, the access information. On the cover sheet, should you need it. But it's a nice way to get a hold of the information for all this stuff. So you don't need to have that sit up there. Now, mediation, what is it? It's a process where you sit down with an impartial party, and that would be me or Terry Wilson. We're the two mediators in the county. And by the way, I'm not saying this because I'm looking for more clients. I'm not saying this because we're looking for a lot of business. We don't get paid by the client. We don't get paid any more or less depending on what our clients do. I'm sharing this with you because this is what parents have told us works. I could meet with nobody else the rest of the year and I would still be paid the same amount of money. Believe it or not. We have more than enough clients. That's not why I'm doing this. I'm doing this because this is what parents tell us works for them. And anyway, you sit down with the impartial party, and you work out the agreement. The purpose is the mediator writes up the agreement that you want. In mediation, you still maintain all the control. The mediator is not there to tell you what to do. The mediator is there to write up what you and the other parent want. So for example, you may be sitting there and say, well, I don't know exactly how to put it into words, but this is kind of what we want. Don't worry about how to put it into words. That's our job. We're the ones that put it into the words for you. You tell us what it is you want. It's our goal to keep you out of court. Sure, it's nice to keep you out of court for your sake, but primarily for your children's sake. Because this is a traumatic process for children when you end up in court. How much? A mediation is $125 a piece. It's a flat fee, regardless of how many times you meet. The shortest I've ever met with a family was 45 minutes, and the longest was 38 times. I would venture to say that most of you would be somewhere in there. If you were going to mediate, you probably would have a better feel than the mediator, especially in the beginning, about what your concerns are, what your process might be. How long? Again, it depends on only the two of you. Who attends? Only the parents. There's a real logical reason why. You are the only two people who can make the agreement. You are the only two people who, if you can't follow it, can be found in contempt and fined. You're the only two who are responsible. That's why you're the only two there, because your agreement can't include anybody else. It's just the two of you. Mediators don't make any decisions. And what do we actually do in mediation? Well, come up with some other ideas. The first thing is problem solving. And that's what the key to all mediation is. If you're stuck on something, this parent's saying black, this parent's saying white, it's up to the mediator to say, well, how about purple or green? Well, maybe that might not work, but blue, that would be okay. The two reasons we might be able to do that. One is, that we're not your family. It's that old you can't see the forest for the trees thing. Maybe we can see something that's just as plain as the nose on your face, that you can't see. I had a family in mediation where mom worked nights, dad worked days. They had 3 little children. Each one said, oh, I've got to be the main parent. I can't be the alternating weekend parent. And first of all, I don't know why they thought those were their only 2 options, but they did. That's what they figured. And I said, oh gosh, let me just ask you this question. What if you had the kids during the day and you had the kids during the night? Well, hang on, get some paper. And man, all of a sudden, thoughts were flying and they were working, they just had never thought of it. And it's not that I'm so brilliant. I actually was kind of thinking, if you did something like that, when would you sleep? Because sleep is real important to me, As a parent, I think we all love sleep. The second reason that we may be able to do that is, again, not that I'm so brilliant, but I've written thousands of agreements and no two have ever been the same. So it's not that I've come up with some great things, it's a lot of the people that I work with. Parents are great and creative, and so maybe I can share something somebody else has come up with that you can take and tweak, to work for your family. Second thing is a reality check. People say, oh, I don't know, what do you think's gonna happen? Well, first of all, no one can tell you what will happen. Excuse me. If you go to court. Pardon me, I have this flu. Not your attorneys, not a judge, no one. But what I can tell you is things that I've seen happen in court. I would not presume to tell you what will happen for you. And some of the things that I've seen happen in court, where do I get that information? I get it from sitting in on court cases and following up on any case I have that doesn't settle. There are very few cases that don't settle. But of those that don't, I've gone back and I've looked to see what happened when they went to court. Now I can tell you that the judges have always told me that the worst mediated agreement is always better than the best court fight. I've not always believed them, but I'm a very slow learner. But what I can tell you is that in those cases I've had that haven't settled, in every case over these years, without one exception, what they ended up with in court was worse for them than what they had sitting between them in mediation. And sometimes it's worse in big ways. Excuse me, issues that were not addressed. Sometimes it's in small ways. Little details that the judge just couldn't consider. For example, this parent is the soccer coach. Soccer is always on Saturdays. The other parent gets Saturday placement. Okay, it's not the end of the world. It's a nuisance. But if those parents didn't agree to it, the judge isn't going to be able to take the time to think about that schedule. So one of the big things that you want to know is anything you can agree to, you keep control of it. Anything you don't, you'll see this slide up later, you hand over to the court, to the state. The other thing is this. Any judge will tell you that when you come into that courtroom, they totally discount everything that you have to say. And that's not what you want to hear. They discount it because their presumption is that you're all biased. Well, of course you are. You're coming from your own point of view. Whose would you be coming from? But the people they presume are not biased would be the guardian ad litem and the custody placement evaluator. And what's more is, any witnesses you have coming in, they're also biased. Now, I had a parent say to me, do you mean to tell me I'm not paying my mother? No, I'm not saying you're paying your mother. I'm just saying that why would you call someone to support your point of view if they weren't coming from the same point of view? They're also biased. So again, when you're in the courtroom, one of the things that you hear all the time in the halls is, oh my gosh, they didn't even listen to me. I had all this stuff. I couldn't even say this. He wouldn't even let me talk. You know, well, they discount everything you say anyway. You know, the other thing is that the judge can only hear what's based in law. If it's not a legal issue, you're going to be pretty stuck. Yes, ma'am.
Did you say the court orders mediation?
Yes. Yes.
Did that happen at a first hearing?
That's an excellent question. This lady just asked, does the court order mediation? It does always order mediation for us. We're different, you know, for the court ordered mediators. There are two ways that you can come into mediation. You can come into mediation, maybe you're going to a hearing and the judge says to you, well, how's it going? Do you have your custody agreement settled? Well, no, we're having trouble. He's ordering mediation. Because they just know. They know it works. So, you know, that's what they want to do. The second way is at any time, one of you, it only takes one parent, can send a letter to the court commissioner requesting mediation. And he will put through an order for mediation immediately. And the reason I'm saying that again is not that I'm trying to drum up more business, but there's a lot of people who say, well, let's kind of get this thing moving, and can we do this, you know, can we start this like now, you know, and before we wait for another hearing, that type of thing. So but the end result is there will be an order for mediation that enables us to mediate. We have to have that before we mediate. Did that answer your question? Okay, that's a very good question. So again, I might be saying, you might hear us say in mediation, well, this is something I've seen happen in court. If I say that, or if Terry says that, we are not telling you that we know what's going to happen to you guys when you go to court. We are literally just saying, this is something we've seen happen. Because we're just trying to give you more information. It's very important to us, again, that you make educated decisions for your family. So, you know, that's the reason we might say that. It's not that we're trying to back somebody into a corner. We may not even think that the judge's decision was right. Because in fact, most times, we know a whole lot more about this family having sat with you in mediation than the courts do, even after a home study. Because we've heard it right from you guys over and over again. The third thing that we may do in mediation is say something like, well, kids have told me that they really like this situation, or research has shown this is a good plan for children, you know, in this age group. Neither of us are trying to tell you that we know what's best for your children. We don't. I don't know your children. You don't want them to know me. I'm just trying to share information with you. If it makes sense for what you know of your children, use it. You know, if not, you know, don't worry about it. You don't have to please us. Now, this slide talks about the differences between mediation and litigation. Litigation, as you know, is going to court and fighting. And mediation, I've just been talking about. Mediation is cooperative. Parents are working together, problem solving. Litigation is competitive. It's one against the other. Mediation is all about disclosure. Everything is mediation is confidential, which is further on down here. which means that I can't even be called in to testify. I can't be subpoenaed to testify. Anything you tell me is confidential, it stays in the room. Also means that you can come in and be perfectly honest. Yeah, I know, look, I've had a problem with this in the past. This is what I'm doing about it. Now, a ton of a custody placement agreement is about peace of mind. So, if you say, well, yeah, this is what I've done in the past, this is what I'm doing about it. Let's say the other parent says, yeah, but I'm still worried this might happen again. Okay, well, what if we, the mediator says, write in language that says, this will or this will not happen. And if this happens, this is what we'll do. Okay, well, I'm not going to do it anyway. I just said that. Great. But since you're not going to, what if you have it written in? Well, okay, because what does that do? That gives this parent peace of mind. You know, when you're breaking up, you know, here you are going along and you're thinking to yourself, oh my gosh, you know, I've really blown this now. And I don't know if I can trust myself, no less trust somebody else, because I thought the relationship was this way and it wasn't, and so what am I going to do? And there goes the child with the other parent, and this is what I'm worried will happen or won't happen. But here I have in black and white this agreement, this legal thing that says we agree that we will do this or we won't do that. And we both signed it, and it's an order of the court. And what's more is, if the other parent violates it, there's something I can do about it. And that something that you can do about it is you can file a motion for contempt, which has a far lower burden of proof than anything does in criminal court. So for example, if you were trying to take the other parent to court for not having the child in seat belts, you're going to have tickets. Because otherwise it's just going to be he said, she said. Unless you have that in your agreement, then you're no longer talking about a criminal action. You're talking about basically a person having contempt for the agreement, not following the agreement. And then when the judge says to you, how many tickets does the other parent have? Well, none, Your Honor. All right. Well, what other evidence do you have? And that's huge. So, do we have a, okay, that's good. So, you know, it gives you a lot of peace of mind, enormous peace of mind. In mediation, and litigation is all about deception, you know, it's like, let's not put it on the table, I'm gonna hide this from you, so you don't know about it, so you're not gonna hold it against me. Mediation encourages communication between the parents. After all, you're the two parents for the rest of these children's lives. You're gonna need to figure some of this stuff out. Litigation discourages, don't talk to them now until we see them in court, and then we'll talk through the attorneys. Mediation is about mutual problem solving. We gotta figure this out. Whereas litigation is about self-enhancement. Gotta make myself look better. So I'm the better parent. That's the good parent versus the bad parent. Mediation builds on parental strengths, and litigation on parental inadequacies. Pretty obvious. Mediation addresses the needs of the parties, and litigation addresses the positions of the parties. This is the difference between a need and a position, and I'm going to talk a little bit more about that later. A position would be, I want 50-50 placement, and I want it now. The position might be, I need to be involved in my children's lives. There's a big difference, a big difference. When parents walk into mediation saying, I want 50-50, they're talking percentages, they're talking numerical things. Then, as mediators, we need to just sit back. Okay, let's gotta wait this one out until parents start getting practical. Because it's not about percentages. It's about Thursday at 4:30 when soccer practice is over, who can pick him up. That's what it's about. As soon as parents stop talking about percentages and they start talking about schedules and who's available, then we know, okay, now we're going somewhere. Let's get down to it. Let's craft this agreement. Let's figure out what's gonna work for this family, and these children. That's when there's a big turn. Mediation is about future orientation. I can't tell you how many times I've sat in mediation and said, this is not so much about where you've been before, the way it's gone. This is about how you want it to go from right now forward. If you don't want it to happen that way before, then let's figure out where it's going to go. Whereas litigation is all about how it's been before, really not looking forward. Mediation is about empathy, trying to figure out, okay, where are you coming from on this? And litigation is about intimidation. kind of making sure, you bully one person into something. Mediation is self-imposed and you maintain control. Nobody's telling you what to do. It's totally up to you. Whereas litigation is all other imposed and no control. Once you decide in mediation that you're going to terminate mediation, that you can't agree on something, basically what you're doing is you're telling the state, we can no longer make parental decisions for our children in these areas. You must do it for us. You're handing control over to the state. Mediation is all about creative alternatives. Well, this wouldn't work. Well, how about this? How about that? We are only limited by how creative we can be in writing and language that will address whatever concerns you have. And litigation is about win-lose judgments. Mediation maximizes your options and litigation limits them. Mediation is private and confidential. Litigation is open court. I don't know if you know that, but your case is open court. There will be people that don't know you. Maybe it'll be Law Week, which is coming up in April, and there may be a class coming and sitting in there. And here's your most personal, painful, private stuff, and there it is out there. And also, mediation is $125 a piece, and there's the cost for litigation. $150 down payment for the custody placement evaluator. There's hourly fees. The final bill comes at the end of the trial. $350 down payment for the guardian ad litem. Hourly fees come at the end of the trial. The attorney fees you have, expert witnesses, child care, time lost work, emotional cost, trauma to your child. Your children will remember this. Some things that the mediator helps you to do. Identify the issues, facilitate communication, reach a consensual agreement. People that mediate their first agreement, they litigate far less in the future. People who begin by going to court, we got to settle this in court, nope, we're going to court for it, that's how they tend to settle their agreements forever. They're back in court all the time. They're called chronic litigators. They're back in there. Well, no, I don't want him to go to this camp. Well, yeah, but, but it'd be so, he really wants to take, well, he doesn't tell me that. Okay, so it's that kind of thing. There are 3 possible outcomes in mediation: a complete agreement, a partial agreement, and no agreement. A complete agreement would be, you got everything done. Well, how long will that take? I don't know. Again, I don't know your issues. Let's say you met a couple times, you say, okay, this is good. Every time you meet, we give you a copy of where you are in the draft for 2 reasons. One is so you can double check us, make sure that we've heard you accurately and recorded it. Second is for your sake. Take it home and look at it. Maybe you've got a 2:30 in the morning revelation that this was, wow, what was I thinking? This was stupid. I got to do this now. But let's say you've got a couple meetings and you say, yes, this is what we want. Copy for each of you. And if you're working with attorneys, copies go to your attorneys. We don't include your attorneys until that point for no deep, dark reason. It's not that we're trying to shut them out or anything. It's just that up until that point, if it's still like, we're thinking about this, we're thinking about that, I don't know what we want here, until you say, yeah, I think this is what we want, to include your attorneys every step of the way would just run your bill up. So, when you say, yeah, I think this is what we want, that's when they get copies, because they need to see that. They're your advocates. They're there to help you go over it. You sign it, return it to us as mediators, we file it, and you never go to court for it. That's it. You're done. The second option is a partial agreement. The basic rule is that anything you agree to, you keep control of, and anything you don't, the state takes over. If you're wondering, how can you tell the difference? That's it. Real simple. So, let's say you've got everything settled, but you just can't figure out what to do with this and this. So maybe it's what happens with the kids in the summer when they're not in school, and how you're going to get them back and forth from house to house. At the top of the agreement, it says a partial agreement, and as you look through, summer placement and transportation, they're not even in there because you didn't agree to them. So that's why they're not in the agreement. But there's a cover letter that goes with it. And the cover letter says this is a partial agreement, and the disputed issues are summer placement and transportation. Now, I can't say what you want and what you want, because that would be being your advocate. And I can't do that. I can just say what the general issue is. You sign off on it the same way as do your attorneys. When I file it with that cover letter triggers the state to come in just for those 2 items. They leave everything else you agreed to alone. So maybe you've got your entire holiday schedule, including when your grandmother takes the turkey out of the oven on Thanksgiving Day, and the Darien Corn Fest, that is a family reunion for the other parent, and and all this other stuff. You got all that stuff figured out in there. What to do with Sunday school, any of those things. You've got this all this stuff in your agreement, but you need to go to court about summer placement and transportation. Third option is no agreement at all. Say, that's it, I'm done. Mediation is terminated. Fine. All I do is I send a letter immediately. I walk it right into the judge that says mediation is terminated, and that tells the state to come in for everything because you didn't agree to anything. And again, the judges will tell you that anything you can agree to is better than nothing. This is what I mean by the state process. Your child gets an attorney called a guardian ad litem. You don't get this attorney for them. The attorney is appointed. And this is attorney who represents your child. You pay a $350 down payment. Hourly fees come at the end of the trial. The GAL, it's the acronym for this, interviews and observes the child with you and any other person in the household, interviews anybody and anybody they feel is necessary to figure out what should be done about whatever you've disputed. So if it's 2 or 8 items, it's entirely different than if it's a whole agreement. Not just in the intrusion into your pocketbook, but into your lives, into your friends, your co-workers' lives, and especially into your children's lives. And then when you go to court, he presents his or her opinion on what should happen with whatever you've disputed. The evaluator. In our county, it's Mary Ann Armaganian. Is a professional, a social worker, a psychologist, or a psychiatrist who evaluates custody and placement issues. You pay a $150 down payment. Hourly fees come at the end of the trial. Completes a home study, does all the interviews, and this person also presents what he or she feels should happen. And again, we talked about this a little while ago. Anything you could agree to, you keep control of, but anything you can't agree to, the state takes over. And there's the little message from the judges. By the way, all of our judges truly believe that you are the people who are best qualified to make these decisions. Everyone within the system knows the state makes a very poor parent. It's not a job that they want. Now, we need to talk about the law. Custody in Wisconsin is who has the right and responsibility to make 5 decisions for your children. Those 5 decisions are under the age of 18. Just try and tell them what to do once they're 18. The right to marry, enter the military, driver's license, non-emergency health care, and choice of school and religion. Joint custody says both parents will make these decisions. Sole custody says one will. You could have sole custody and never have your child live with you a day. You could have sole custody and you still do not have the right to say, yes, this child can go here or can't go there. That's not a custody decision. It's not one of those 5. Now you need to think about, okay, what would we do as parents for any of these? Consent to marry. I will tell you that in all the years I've been doing this, I have never yet seen this be an issue for any parent, the consent to marry. I've seen parents say, I want written into our agreement that our children will never get married. Well, again, you didn't listen to your parents, did you? Our children won't necessarily listen to us. So you need to let go of that. And once they're 18, they're doing what they want. Enter the military. They're going to need to be 18 because they're going to have their high school diplomas. The military is not accepting GEDs right now. So chances are they're going to have their high school diploma. Another moot point. The driver's license. You're going to wait 16 years for this pleasure. Usually, what this comes down to is if the child is doing well in school, is not in any other kind of trouble, maybe you want something written in and can contribute 20% of the insurance, then he or she can get their driver's license. You can also put in things, that they have this average. Now, I just did an agreement last week for a family that has a 3-month-old child, and one of the parents wanted this clause written in. And I said, so what happens if, as your child is beginning in school, you find out that because he wanted an A average, he wanted the child to have an A average. I said, what if you find out that your child has a learning disability, and no matter how hard he works, and this is a really good kid, he just can't get an A in math? Well, then we do something. I said, well, then you want to be careful how you have this written in. You know, so there's certain, you want to be aware of that. But there, you can actually specify that. Non-emergency health care. This is the one that seems a little vague to people. When you think of non-emergency, think non-essential. Unnecessary. So why would you take your child to do things? Maybe it's a mole removal. Something that could be debated whether or not it's essential. Braces. Now I'm going to warn you about braces. If you take that battle into court, here's what the judge is going to say to you, because every judge knows what that battle's about, and you guys do too. The judge is going to say, so tell me, why is it that you want your child to have crooked teeth? And what are you going to say? Because I'd like him to look like a doofus and have everyone make fun of him? No. Everyone knows it's a matter of, how are we going to pay for this? You can save yourselves a $13,000 court battle by figuring out how you're going to split, that money. That's a lot of braces that you can get for $13,000. So, you might want to think about that. Where this one does get difficult are sometimes the medications for things like ADD, ADHD, tubes in the ears, things that are debatable whether or not they're necessary or not. This is a very difficult one if it's brought into court, because it comes down to a hired gun situation. You're going to have to call in expert witnesses, and it comes down to not who is the best doctor, it's who is the most credible witness on the stand. Which witness is the one that the judge believes is right? Now, you may have the doctor that's known the child since birth, but the other parent may have the doctor who is the expert on this medication from New York City. All depends on who comes out better. Maybe your doctor will, but maybe the other one will. Who knows? The reason I hate those is because it leaves the decision to somebody who's not one of the parents. And you are the people that are going to care more about this child than anybody else. And then the last one, choice of school and religion. If that's been an issue, you probably know it already. But you need to be looking at where are the children going to be going to school, and you want to specify anything concerning what religious practices they have. Now, placement is the big deal. And by the way, those 5 decisions we talked about with custody decisions, they're not the decisions you make every day that define you as a parent. They're not the ones that when your children say, oh, who's my mom? Who's my dad? What kind of things do they do? They won't let me get married. It's not that. It's these decisions. It's placement. Placement is where is the child when, and when the child is with you, you have the right and responsibility to make routine daily decisions concerning their care. What are those? Anything that's not one of those 5 custody decisions. So think about it. Pretty much everything. What time are they going to go to bed? Can they have pizza for 5 days? Do they ever have to bathe? Does he have to brush his teeth? Can they do their homework? Who's going to come over? Who's going to babysit? It's all that stuff. Those are the things that tell your child, yep, this is who I am as mom or dad. Now here's the other thing. The court is told that each of you will have periods of significant and meaningful placement that maximizes your available time with the child. You are each going to have placement. You need to figure out what's going to be practical for you. Some other little facts about placement. People are always saying, at what age can my child decide? 18. It's not 14. It's not 12. Why is that? Think about it. Children do not always ask for what's best for them, regardless of their age. And we're going to talk more the second day about things that children may ask for. The children's wishes may be considered by the appropriate professionals. They would be the guardian ad litem if you end up going to the home study. But why not by you? So, practical is the key word here. You need to be thinking very seriously about what's going to be practical for you. What's going to work with your work schedules, with the children's schedules. Again, you are the people who know this stuff the best. Now, we want to take a quick break and come back. And so stand up, spread your legs. Opposite sex makes no difference. 2, 4, 6, I think we have an even number, so I think this is good. Hurry up! Faster, faster! Does everybody have a partner? This lady doesn't. Wait a minute, do we have two? Because we have one lady over here waiting for a partner, so you've got three. So we need one of you to go over there. What? Well, come on, hokey puppy. Okay, now what?
I guess I'm
No, you're not.
I was lazy.
No, you're not. You're grandpa. You're grandpa, and you're back here with this couple right here. Okay? Now everybody, but okay, all right.
Progressive.
Yes. Okay. Here's the issue. Parent A says the child needs to go to private school. Parent B said the child needs to public school, goes to public school. I want you now to take just a couple minutes, talk to the other parent. How would you resolve this? What would you do? Just a couple minutes. No wrong answers here, by the way. Go. You're A. Now you are. You're B. Okay, who's got an idea? Somebody, give me an idea. Yes, sir.
Well, first off, we came up with get the child's input, find out
Okay.
what the child wants. You know, I would assume in this scenario the child's already in public school and
Okay.
he is moving to a private school. Does the child want to start over, make new friends? In my personal opinion, that would weigh a lot in my decision.
Okay.
Is does he want to go? Does he not want to go? And the reasons for both.
Okay. Anybody else have an idea? A thought?
Parent A is stuck on a private school, parent A gets paid for it.
Okay. If parent A is stuck on the private school, parent A should pay for it, she's saying. A good thing to do is, and that's where, remember when we talked about in mediation versus litigation, mediation is about empathy? You got to try and figure out where is that other parent coming from? What are they really worried about? If the other parent, in this case it would be dad and grandpa, if dad, who's got to live with grandpa, if dad is worried about, you know what, I don't really have an objection to the school, but I can't afford it. I just can't afford it. If that's the issue, then that's a good possible solution. Any other thoughts? How are they going to get there? What about transportation? Maybe that's the issue for the parent. You know, you want to try and see, okay, where are you coming from? What are you worried about? And the big question is, what are you worried would happen if, you know, this happened? It might be that, let's say it's an issue where maybe parent A feels that the child's needs aren't being addressed in the public school. You know, maybe the child needs smaller classes, smaller classrooms. And then maybe parent B says, well, yeah, but you know what? He really has special needs, and they don't have a special ed program in the private school. You know, so you may want to look at that. There is a standard by which people can measure schools. It's called the WKCTE testing. And it's testing that they deliver in certain age groups, 4th, 8th, 10th, I believe, and where they look at the rankings of the schools. You know, sometimes parents will write in, okay, we will examine which school district, you know, does better in this area. Sometimes it's a matter of, a lot of times I'll have parents coming into mediation and they'll say, okay, we don't know what we want to do with this issue. And I'll say, okay, do you want to send this to the GAL and the evaluator? Because here's what they're going to do. They're going to go to your school, the schools, to figure out which one has a better program for your child. Or, what if you guys do it? What if you both go and you get all the information, bring it in here, let's lay it out on the table. You guys make a decision, you know, based on this. But before you go out and get the information, let's decide what is it you're going to be looking for. Okay, we're going to be looking for this class size. We want to make sure that they have a strong English program. We want to make, you know, whatever it is, you know, so you can do things like that. So that was great that you guys came up with some ideas, you know, about where is the other parent coming from. And by the way, in some groups, although it did not happen in this one, because we have a bad grandpa in this group, sometimes it was really important to grandpa that this child go to the private school, so sometimes grandpa offered to pay. Not this grandpa, but some grandpas do. Okay. What about this one? Now this could be real touchy for this group here. But my parents need to spend time with the kids. And the other parent says, well, so do mine. Okay, so, real fast, talk to each other. How are you going to deal with that? This actually may be very easy for you since you're stuck living with. All right, who's got an idea about this one? And how are you going to mix those grandparents in there? Yes, sir.
The easiest time, like with my situation is, my time with my parents are figured into my schedule.
Okay.
Which should, be a part of on my responsibility because they are my parents. Where it would be worked into with the weekends. My parents happen to live 500 miles away.
Okay.
So I mean, it rolls down to summer times that, okay, fine, I'm taking the kids up north for the weekend or for the week or whatever.
Okay.
And that's where you hope you have good mediation skills between you and your other parent or the other parent in this situation to negotiate that.
What are you going to say?
I was gonna say the same thing.
Okay. Anybody? Yes, ma'am.
We brought up an issue too, what if if there's something special, anniversary or birthdays, and I feel on that part, you would sit down with your ex-spouse and say, okay, my parents' 25th anniversary is this day, or 50th anniversary is this day.
Mm-hmm.
Could I please have the kids, and hopefully if you're that.
They're nice.
Yeah, I'm nice. So I would say, sure, go ahead. And maybe a week or a month, if you know that that's coming up within months, sit down with that parent and say, I would really like it if our kids were there for that special event. And,
Yeah. And that's great. And that's great that you brought that up because we're all going to need time like that. Stuff happens, and you're going to need a little bit of that. The other parent's going to need a little bit of that, And so if you want to get some of that back, you got to give a little bit of that too. And some people want it all one way, but it doesn't work. So if you think you might ever want a little flexibility, a little give from the other parent, it really helps, if you're going to do that. The other option, another piece of that is you can have vacation placement written into your agreement, and you can always, and that's kind of like a trump card that you play. You can always use one of those times, for that, And where the law falls on this, in case you were wondering, is really where you guys were all coming from instinctively. Is okay, if it's my parents, I got to figure out when I'm going to do it on my time. And if it's your parents, you figure it out. Sorry, Grandpa, in the back. Whoops, there's that. Okay, next one. This is sometimes a tough one. I want equal time. 1 week is too long for me to go without seeing the kids. I need to be both the fun parent, which is the weekend time, and the drudge parent, school days. Guess I need total placement. And the other parent says, predictably, me too. Me too. Okay. What do you think? All right, let's get back to this one. You guys are getting better and better at this. Who's got some ideas? Hang on. How about this couple here? You guys are plotting something out. Do a big.
I was saying that, I know you don't like the 50-50, but we have my daughter.
I didn't say I didn't like 50-50.
But
Yeah.
realistically, it's 50%. So if you look on a 2-week
Mm-hmm.
part, I have my daughter Thursday night, Friday night, Saturday night, Sunday night, which is a weekend.
Mm-hmm.
She has her Monday night,
Mm-hmm.
and I have her Tuesday night, Wednesday night, Thursday night. So and she has her Friday night, Saturday night, Sunday night, Monday night, Tuesday night.
Mhm.
So it's 7 days out of 14 days.
Mhm.
I have her, she has the other. It works out so it's,
Yeah.
it works out so it's every other, so I have her every other weekend.
Mm-hmm.
So I have a weekend, she has, not, but she's young, so she's not in school,
How old is your daughter?
18 months.
18 months.
But, still, as long as you live in the same town,
Mm-hmm.
you can still both get her to school. It works out fine.
Anybody else have another plan? Yes,
I
ma'am.
just have a statement one thing, the weekend should still be looked at as fun time with your child.
I'm sorry, I'm just,
Every day should be fun with your
okay,
child.
every day should be fun time, okay?
No, it should not be analyzed like that at all.
Okay.
There's nothing you can't do.
You know where those terms have to do with, you know how it is on school days. You got your get home, you get your homework, you get the, you gotta get your bath, if you got a chore, whatever, and then it's time for bed. And a lot of times parents will say, I just feel like I have no time to do something fun, like we can't go to a museum this day. You get all the weekends, you get all the fun time, you get to take them to museums, it's that kind of a thing.
We have other weekends, it's like, that's what I have, and he has different days, but, it averages every other week too.
Okay,
That's the
Yeah.
easiest way to do it, and balance your schedules.
you can do that. Yes, ma'am.
It's not quantity, it's quality of time spent with the kids.
Okay.
What's more
Yes, sir.
Kind of an off the wall thing, but it works in my situation is if you can get along with the other parent, do it together. That way you're not the evil parent, bad parent, you're equal parents sharing a fun activity with your kids. Hopefully you can get along at least enough for that day. I mean, I'm not saying you gotta be friendly, holding hands or nothing, but you can show you show your kids that you can get along civilly enough to do this, and that both parents can show the child a good time.
As long as this gentleman's bringing this up, are any of you familiar with the bird's nest placement schedule? Because some of you were choking at what he was saying, so I just would kind of like to see you choke big time at this one. This is what the bird's nest arrangement is. Parents get together and they say, it's not your fault as children that this has happened. There's no reason to have your lives disrupted. You stay in the house. We'll move in and out.
Ooh, that's good.
And the parents move in and out of the house. The children never move. They're there, same bus stop, same friends, same, carpool, whatever. And the parents move in and out. Everyone that and we do have this in Walworth County, in case you're thinking this is only Hollywood. And I'm not, it takes a certain kind of relationship with the other parent to do this, by the way. Now, every agreement like this that I'm aware of, that I've done, the parents also jointly rent the outside apartment or whatever, because economically, that works for them.
I was gonna say that's.
In a number of these families, here's what the issue has been. Housing prices have gone down. We can't sell the house and recoup what we both need, so let's hang on to the house and we'll do this. It works, it's worked for them. I'm not saying it'll work for you, but just when you think, okay, there's only this or this plan, it's like there's something that you may think of as so far out there. But what the parents have said is essentially, again, it's not your fault. We've done this. We're gonna bite the bullet for the next 6 years, so you can keep going, and your life's undisrupted.
Well,
Yes, sir.
If you're doing that, and you're both sharing the cost of that apartment, who's paying the mortgage on the house?
Okay.
Everything.
They split everything.
Split everything.
I was gonna say, in my case, I have an apartment downstairs in my home, and that's where I live, and my wife lives upstairs. The kids come up and downstairs freely as they want.
That makes
She works
transportation
nights-
easy.
She works nights and I work days, so there's
Mm-hmm.
not a lot of time for us to really interact anyways. So there's less bickering, there's less fighting.
What should be popping into your brains right now is that there's no two agreements, as I said before, that are the same. What works for you may not work for you, but you don't have to do what anybody else thinks is the right thing for your family. There is no one way to do it. Now with this plan, this situation up here, another plan that a lot of parents like is this. And one of the other issues that they have with this particular, situation here is they'll say, but I want my kids to have some stability. I don't want them to have like such a schedule that they don't know like what's gonna happen on this day. And I'm worried about their school days, being disrupted. It's that whole thing. So here's a plan that some people have come up with. And again, I'm not saying you have to do this, just another idea. Mom, parent A, let's say, always has Monday and Tuesday. Parent B always has Wednesday and Thursday. And they alternate Friday, Saturday, and Sunday. Kids always know. Monday, Tuesday, parent A. Wednesday, Thursday, parent B. And then they alternate Saturday, Friday, Saturday, and Sunday. So that may be yet another option, another thought, for that. It's kind of just a little step away from where this gentleman was going. But again, you should be thinking about what will work for us. What would we be good at? Children need to be with me on Thanksgiving Day and Christmas Day so that we can have our traditions. And guess what the other parent says? Okay, this should be a fast one for you. Go. How about you two ladies back here? You haven't got to say too much.
For this,
Yes, for the holidays.
do it together. That's what we did.
Okay, do it together.
I invited.
And you realize there's lots of carving implements that are available on both of these holidays? There's sharp cutlery,
I don't take my axe. We did it jointly. I guess I invited him over for Thanksgiving, and he came for dessert. I had the kids for the major part, he came for
Okay.
dessert. And then Christmas Day, he came at 6 o'clock, and he watched the kids open their gifts, and we had a nice meal together, and then he left to go to his families, and I left to go to mine.
Okay. Anyways, this duo back here, they had this whole thing settled.
Wait, you said you left, he left, where'd the kids go?
They went with me.
Okay, just wanted to make sure, you said he left,
He's still thinking that bird's nest thing.
Thanksgiving, he had them, he took them, he had his family
Okay.
for Christmas, but we did it together.
Okay. Did you guys have something else? Because I know you were the overachievers.
No, you're not.
Yeah, you have.
My husband did one.
Okay, alternating them? Okay, alternating?
Or take like.
Split the day? Hard to do if you're like you've got families that are far apart. I do have this theory that I think they should, like, when people get married, because the statistics are that about 50% of people who marry will divorce. So I think only people should marry whose families celebrate Christmas either on opposite days, like Christmas Eve and Christmas Day. They should never permit people to marry whose both families, celebrate on Christmas Day or Christmas Eve. But no one listens to me.
Dan, you could already have your divorce mediated before
There you
you
go.
say I do.
There you go.
And it's halfway over.
That's right. It's all done. Forget a prenup. Let's do a pre-me. Yeah. None of you asked me this question, but I'm going to pretend that you did. Just so you know. I'm going to pretend that you asked me, what's the best holiday schedule for children? Well, here's the deal. You may not like this answer. If you're talking purely from a child's point of view, the best holiday schedule is for the child to have the same holiday schedule every year. Alternating holidays are actually more difficult for children because that means that they don't have these traditions to look back on. They can't say, well, in my family, we always, we do this. Now, at the same time, I'm not telling you that each parent should not have holidays to celebrate with the children. It's critical to do that. Here's what I am going to tell you. Your children are going to be willing to believe that they are so special that Santa will come to them 2 different places, 2 different times. It's not going to bother your children for you to craft your own holidays. The people that you have to worry about are not your children, and probably not even the 2 of you. You know what I'm going to say. It's your families. You get over here, you tell my mother we're not going to be there when she bakes that big flan. No. Sometimes you have to say, you know what, Mom, Dad, this is the best thing I need to do for my children. This is what we're going to do. I'm going to tell you now the slickest Christmas holiday schedule, because that's usually the big one, the one that children like the best. Purely from the child's point of view, factor out parents, okay, is parent A has the first half of Christmas break, parent B has the second half of Christmas break. When does parent A celebrate Christmas? Probably Christmas Eve and Christmas Day. When does parent B? Most of the ones that I know do it New Year's Eve and New Year's Day. Kids love that. They love it. It makes, they've got festivity on either end, just when all the shine is off, all the fun stuff, for the first half. They've still got one to look forward to in the second half. Now, if that causes conflict between the 2 of you, that's going to be worse for your children than alternating holidays. Okay, so in other words, if you guys can't deal with that, then you may need to alternate holidays, because The parents arguing is worse than anything is for the children. Okay, so you need to look at what in fact is going to be practical, and practical considering your feelings with your families. You can do many variations, by the way, of that type of schedule, where you would do one parent A has the first half, parent B has the second half, and you pull from the formula of days, Christmas Eve and Christmas Day out, and you split those up a different way, so you can do that. Thanksgiving is a nice 4-day weekend. Maybe parent A always has Thursday and Friday, and parent B has Saturday and Sunday. Kids are going to be happy to have 2 different holidays. They like that. In fact, they like fabricating this stuff. This is special for my family. This was hard for me as a parent to wrap my brain around, until my kids came back to me and said, oh yeah, in our family, meaning my 2 children and myself, we always, which we did not, we always have Thanksgiving the Saturday after after Thanksgiving. That's what we always do. Well, we did that once, the very first Thanksgiving after my husband and I separated. But every year after that, they insisted that even though we were together on Thanksgiving Day, that we also had our own private Thanksgiving with just the 3 of us on that Saturday. Where it was just the 3 of us, and we just did certain things, and we had this, and we have the icky Brussels sprouts, and the terrible cranberry sauce that they don't like that I make, and we have the cinnamon rolls, and we have to videotaped the Macy's parade, and all that stuff, and watch it, which I swear I never sat and watched the whole parade, it was just kind of keeping them busy, but that's what they said that we always do. Well, I didn't know we always did it. By the way, your children know the traditions that you have. So be thinking about those things that are special, to your children, for your children, also having to do with holidays. The people that are good with the holiday stuff in custody and placement, get it down to the few that really matter to them, and just let the others fall away. At the same time, there are some things you might want to add in. I can't tell you how many agreements I've done where the Darien Corn Fest is an important day because many families have family reunions. Maybe your Aunt Sadie has a Bratfest and a Carnival Walk the last Thursday in October, so maybe you should have your children the last Thursday in October, for that Bratfest. So be thinking about that. But there's the holiday schedules. Megan loves basketball. It's good for her. She's in high school now. If she doesn't play in every game, she may be kicked off the team. And some of the games are on my days. I live 97 miles away and I can't get her to. What are you going to do? By the way, these are all mediations that I've done. These are all right for my mediations. Go. Okay, who's got a response for this one? Yes, sir.
Well, the simplest being a dad in this situation, I would allow my daughter to have her games, which are important to her at this age, and I would make up the time the week before, the week after. I would make up arrangements with her mom.
Okay.
Because this is important to my daughter, and what's important to her is important to me because she comes first in my life.
Okay, you ladies were saying something?
That's what I,
Similar, if Megan is obviously old enough to say whether or not she's really into sports and would be willing to give up the time to parent B, but then yes, parent B could say, well, if I can't do these games, then could I pick up days?
Okay, so the idea is to find time to compensate.
that's what my husband, my ex-husband do. He works second shift, so he misses a lot of her games, so the days that he has off, he takes her,
Okay.
To make up for not going to her games, but on videotape, and so we work that thing out. We work
Good.
that out.
Yes, sir.
If they're 97 miles away, how is she getting to school every day?
I will tell, good question. I will tell you, in this case, this was actually a boy.
Games are during the week.
Yeah. They're also on weekends.
Well, not in
In high
high school
school.
unless they're in tournaments.
Yeah.
games.
Yeah. And this was, Dad lived in Waukegan. Mom lived here. This was a varsity athlete, basketball, and the son was a great athlete, great student. And one of the first things you need to know is, by law, parent A has no right to schedule parent B's time. Okay, so one of you doesn't have any right to say, by the way, when you have the children, you're going to take them here, here, and here, and here. You don't have the right to do that. And so for this one, this father was saying, well, you know what? No, you're trying to cheat me of my time with my son, that's it. By law, the son had to go with his dad. And dad exerted his right before this stuff was over and took the son. The son missed 3 games, couldn't play, lost his scholarship. And here's the big question,
That's
or the big issue. The father really lost his son. When that son turned 18, he lost his son. He lost his son. And so one of the things that sometimes I have to say in mediation is, are you just looking at the next 10 years or the, whatever, or are you looking at the rest of this child's life? You need to think long term. Now here's the other thing. This is a really compelling reason why you want to have something in your agreement about extracurricular activities, how you guys are going to handle them. Because the critical issue is, you say, okay, let's consult with each other before we sign them up. If we both agree, we'll get him there and we'll share the cost. There it is. So, and then you get into a habit of, before he signs up for something, you check with the other parent. If you both agree, then it's a moot point, and the child's always coming to the forefront. These are very, very sad things to have happen. Very sad. And the children, as always, end up suffering. On a little bit lighter note, although these things are mediated, the other parent never cooks. When the kids are with them, all they do is eat fast food and take out, and the other parent says, it's better when that one cooks. Here, just shout out some ideas. What do you think you'd do with this one?
I would cook him some meals and send them with him and say.
Cook some
"Here you go.
meals and
Put
send
it
them
on
with him. All right? Is this something you can mediate?
Yeah.
Absolutely you can. You can mediate, and you can put into your agreement anything that you want to. I have written many McDonald's agreements. McDonald's is not a legal issue. But when I say McDonald's agreements, the judges always chuckle when they get these. These are ones where both parties agree that the child will not eat at McDonald's more than twice a week. Well, there is no law that is going to, if they took that to court, where they're going to get any satisfaction. But remember when I said it's about peace of mind? This was a real worry for this parent, because the child had, in each one of these cases, there were different issues. They haven't written in, I have written up agreements where there's been a page and a half about diaper rash procedures. Not a legal issue. And in fact, hopefully won't be an issue in another year. But it was all about peace of mind. And in fact, because the parties couldn't communicate well, they're sitting there in mediation, I'm writing this up, and actually that totally satisfied the whole issue. Just having it spelled out for the other parent. The other, thank you so much for telling me. I had no idea what to do. I knew this wasn't working, and I didn't, so, there it is. So, here's what you need to remember. Parent A has no right to say what parent B does during play. This is a placement decision. But if you both agree, okay, we will have the child eat whole fruits and vegetables. You can put that in your agreement if you both agree. But if the other parent, we may have, I had one where dad, who was a farmer, said that he wanted his son to make sure that he had meat, red meat, beef, every day. Mom was a vegetarian. Well, so if they go to litigation for that one, they're going nowhere, because the judge isn't going to, help them with that. They're going to just say, it's a moot point. Now, these are on that sheet you have. There are 11 factors when a judge determines custody and placement. These are in your packet in the Summary of Wisconsin Family Law. You can see that the very first one is your wishes. And it goes down and covers many other things. So just consult that packet if you're wondering, what does a judge look at when making those determinations? There are 3 ways that you can get your agreement revised. After 2 years, you can petition the court to make a revision. That means if you want to have the GAL and all that stuff happen, and then you'll be ordered to mediation. Anytime in the process, could be 6 months from now, 6 years from now, you can send a letter to the court commissioner, the same way you could get it ordered in the beginning, requesting mediation, and you'll be reordered into mediation. You do pay the $125 again because it's a new action. The difference between number 2 and number 1 is you never go to court. And this might be, maybe this gentleman said he was working nights and the other parent's working days, or maybe it was vice versa, I can't remember. let's say all of a sudden now he's working days, so they need to have a change, okay? So maybe it's that. The third and simplest way is to run right on top of us here to the clerk of courts, $5, purchase a stipulation form, put your case information on that, write up the change that you want, you both sign it, file it with the clerk of courts, and you're done. You know, there it is, it's made in order of the courts. Those are 3 ways you can get a revision. And some of you may have very young children, you know, so you may need a change. Another piece of legal information, moving. You know you're within a 150-mile radius as long as you stay within the state without giving notice to the other parent. Move outside of that radius or outside of the state, and you have to give 60 days written notice to the other parent. If the other parent objects, they will order you into mediation, you know, to figure out what you're going to do. So if you're in this process now and you know that moving will be an issue for you, put that one on the table. That's an issue you want to put on the table. And because we are a border county, you know, you could move 3 miles and be in Richmond, and you have to get the permission of the other parent because you're outside of the state. But you can move all the way to Sheboygan without permission. It's a whole lot easier on your custody placement agreement to go to Richmond than Sheboygan. And we see a lot of times when parents will say, you know what, can we have written in our agreement that let's tighten the radius, we'll move within 20 miles, 50 miles of each other in Wisconsin or Illinois, just because of where we are as a county. So, you know, you might want to be thinking about that if that's an issue for you.
Can I ask you something?
Yes,
about
ma'am.
that? If that happens as far as that, how do they arrange, you know, transportation and so on and so forth?
That's the difficulty. The issue is, you know, how do they arrange? Basically what you're saying is, how do you maintain your placement schedule if one of the parents moves a great distance away? Distances are a difficult one to mediate because there's no easy answers. It's not a matter of one parent being better than the other. It's a matter of practicality. And a lot of times you end up having to amend the placement schedule, you know, because it just isn't going to work. There's not enough time between when I get off work to get down there to do this, to whatever. So it all comes down to practicality. It all comes down to practicality. Most often the party who has moved will bear the burden.
That's what I thought.
But I'm not the judge. Current research. There are 2 factors that will predict whether or not your children are going to go on to be successful. And I'm not talking about making a lot of money. I'm talking about successful in relationships. This comes from the Wallerstein-Kelly study, the most definitive study, the longitudinal study on children of divorce. The first one says that the parents at the point of the divorce stopped fighting in front of the children. They stopped putting the children in the middle. And the second thing is that the children knew what to count on. Now I share that with you because that is the crux of a really good custody placement agreement, a really good parenting plan. Because if you've each had a hand in making it and it's practical for you, you're not going to be fighting about it because it's what you figured out yourselves, and you're going to be able to be there when you said you would. So your children know what to count on, and that's absolutely critical. And this is what we just talked about. Now, I want to talk to you about an actual case. Here are, by the way, this is also in your handbook there. These are 2 websites that you might want to consult if you are looking for software about co-parenting. The Family Wizard is a way that you subscribe to it, and it's a way to have internet communication that is not conflictual with the other parent, to deliver messages if you have a high conflict. And sharedground.com is another. At the point of your divorce, this is kind of how things shake out as far as where do you fall in style of parenting. About 25 to 30% of parents do cooperative parenting, and that means you've got a lot of joint planning, you've got a lot of talking to each other, a lot of flexibility. You provide support as needed. Shoot, I'm running late for work. Can you pick the kids up? Yeah, that's all right, I got it, no problem. That's that kind of a thing. About 50%, greater than 50%, are parallel parenting. You're going along the same route, but you're not touching all the time. You're not crossing. You have low communication. You don't talk a lot. You don't have to. But you also have low conflict. When I say low communication, always, that's not necessarily a bad thing. If when you're communicating, you're fighting, so you want to keep that. And you're disengaged, meaning that you've got your life, the other parent has his or her life. You kind of got two separate lives. And then less than 25% have conflicted relationships, where you have very poor communication, and one or both of the parents may still be enmeshed. Enmeshed means not just enmeshed in the relationship with each other, but enmeshed in their children's lives. And that would be where they can't separate, my daughter wants to be with me, from my daughter, this is what's good for my daughter, or this is what's good for me. It's like my needs and my daughter's needs are the same, or my son's, or whatever. And that's a way for them to keep in that relationship. You guys, I'm sure, all know people that they're talking about their divorce that might have been 6-10 years ago, and you're saying, oh my God, wasn't that like 10 years ago? Why are you still, okay, never mind. And it's staying stuck in there, it's a way to stay stuck in that relationship. They don't move on. They may even have remarried, by the way. But still, they're still fighting that, and it still keeps them hooked. It still keeps them hooked in there. Now, I want to tell you about an actual court case and tell you what happens when you go to court. And again, first of all, this is a real case. I have changed some of the details because I feel it's very invasive to be thinking about these people's lives. And so I warn you ahead of time, if any of you recognize this family, I'm mentioning their case with the greatest respect. This is very tough stuff for them. But here it is, just an example. This was a 4-week case. There's a mom and a dad and 3 children. And this is the mom over here, and this is the dad. And dad has this battery of lawyers all around him, and mom has her one little lawyer, but she's good. Okay, you're good, you're tough. But you've got your battery of lawyers. And here was the issue. Mom said that dad was evil, and dad said mom was crazy. Mom said that, that the children should be with her. Dad obviously said the children should be with him. 4-week trial. Here it is. The general ratio of preparation to performance is 3-to-1. I'm talking billable hours. So for every hour that your attorney performs in court, that's 3 billable hours of preparation. That's a total of 4 hours. Okay, that's just acceptable billing. That's kind of standard practice. Well, add that up. 4 weeks of trial. Same ratio of preparation to performance for expert witnesses. So let's say you've got a psychologist, and the psychologist is on the stand for half an hour testifying about your children. Well, same ratio. The difference is expert witnesses don't just charge for the half hour they're on the stand, they charge for the day, which means 3 days of preparation. That's a total of 4 days. If they charge, make it easy, $100 an hour, do that one. Expert witnesses, by the way, that's usually a whole separate job. It's like that's what they do. They run around and testify. So 4 weeks. Guardian ad litem, custody placement evaluator, obviously involved in this case. First week was mom's. Okay. Now, mom's attorney had a tough job because mom was unsure of herself. She could get very emotional. If you think it's an accident that there is Kleenex in every one of these courtrooms, you're crazy. Mom gets up on the stand. Mom's attorney wanted to here was her goal. She needed to have mom appear to be stable, reasonable, and competent. Mom gets up. They say, okay, can you tell your name, address? She tells that. This attorney here in the purple of dad's starts writing on the legal pad. Now mom looks over and goes, what the heck? What's she writing? What have I done? Mom's totally, she's getting unstrung. That's like the first week of law school. They teach you how to do that, And meanwhile, she's probably writing a recipe. Who knows what she's writing? But so mom's she's just getting unhinged. But her attorney refocuses her. Tell me what you do for the children. Oh, I get them up, I feed them, I do, okay, great. Yes, and tell me, how do you interact with the other parent? Well, it's been really difficult because everything I try to do, he sabotages me. He hides my medication. He tells the children they don't have to listen to me. If I say you need to go to your room, he tells them, nah, don't worry, you can come on out, you know, your mom's crazy. I try to do their homework with them, and he takes them away, you know, so that they can't do it. He's just terrible. He's just horrible. He's so mean to me, and he won't help me at all with any of this. Okay, now, her attorneys, this one was writing, this one is going to cross-examine her, and it's her job to rip her to shreds. So she gets up there and she says, and you do what? And you don't know how often were these kids late to school? Well, 4 out of 5 days. And why were they late? Well, he hit the alarm clock. How old are you? You don't know how to get an alarm clock? Well, yes, I do. Okay, the tears are starting. And you can't find your own medication? You think, are you competent enough to give your children medication? Yeah, why not yourself? You know, oh my gosh. So she's ripped to shreds. She's a blithering idiot. She goes and sits down. She's had it. They put on the rest of their case now. This is the first week their case. And they've got the school psychologist that has seen the children. They've got a teacher. They've got, you know, the counselor that the children have been seeing. They testify. They establish their expert credentials. You know, this is where they've gone to school. This is what they've done. Yes, this is how they've known the children. This is what they observed. And then what do these guys do back here? These two attorneys, they rip them to shreds. You went to school where? For how long? How long have you known these children? How long have you been practicing? And they discredit them. Week 2, it's his turn. Now, his attorneys have a real job. That's why they've got a battery of them. And it's their job to make him not seem quite so cocky, you know, as he's going to come off. And what's more is they've told him, whatever you do not lose your temper. They've worked on deep breathing exercises with him. They've done all this stuff. Leave the Armani suit at home. I want you to wear just like regular clothes, a regular person would. Oh, okay, fine. So he gets up there and he's pretending to be real humble, you know, and he's look everybody in the eye. Okay, fine. And tell us about your experience as a parent. Well, it's been really hard because, you know, she's crazy and it's been just terrible. You know, she won't take her medication. She doesn't get up. The children are late all the time to school. They're falling behind. It's just awful. They never see, you know, the kids are getting their own breakfast. They're not eating well. Their homework is never done. And what's more is, I don't know why I always remember this one. I went in one day and she put the sock and the egg thing in the refrigerator and the eggs in the sock drawer. I think maybe because that's something I went to. And she, you know, she's just terrible that way. Okay. Her attorney gets up and she says, oh, you know, and what have you done to help her as a parent? Well, I pay for the doctor. Yeah, well, and what about her medication? Well, it wasn't doing her any good. Well, what about the clock? She doesn't get up anyway. Why should she have one? You know, I mean, and she starts poking at him. It doesn't take much. He blows up, you know, thinking, oh my gosh, you know, here we've got damage control. He storms down, you know, sits down, plunks himself down. They put on the rest of they've got the expert from New York City on mom's psychological condition. You know, yeah, she's depressed, you know, and they've got, you know, all these other people come and testify. They build them up. It's their job to tear them apart. And of course, you know, how long have you ever met with mom? Well, no. Well, then how could you know? You may be, you know, so they rip them apart. Week 3 is the state. So the guardian ad litem gets up, and the guardian ad litem says, Your Honor, now there's some words you hate to hear in the courtroom. However is one of them, because just when you think you know which way the wind is blowing, and you know, even in a moment you're trying to get used to it, you're adjusting your, you know, your life to it, and it goes and changes. Your Honor, I happen to agree with him, and now you should see him. I mean, he's, oh, of course you do. You know, yeah, anyone can see, you know, I'm the one, I got it going on. You know, and he is, you know, the more saying, she is nuts. You know, and she's crazy. And those children should not be with her. Well, bring the fleet of Kleenex in. You know, there she's just blubbering over there. However, anyone can see that he drove her crazy. Those children should never be with him. Now, they're looking around. She sees this. She's perking up a little bit. But she said, wait a minute, where's this going? I believe the children should be with his mother. She seems like a very nice woman. Now he's thinking, this is where litigation gets you crazy. You start thinking win-lose. Okay, it's not me, it's not her, but it's not her. It's she's my side, so I think this is a win in my column. Mary Ann Armaganian gets up there. Your Honor, we gotta get that guardian ad litem's vision checked. I mean, I agree with him. It's true, she's nuts. You know, I mean, I've rarely seen someone as unhinged as this. And of course, he drove her crazy. I'd be depressed too if I had to live with him. But anyone can see that his mother has made him everything he is today. That witch has fashioned him into this satanic creature. No children should ever be around her. But I happen to think her father's a pretty nice man. I think her father should have placement of the children. And now she's thinking, wait a minute, this is my side. Maybe this will work. Week 4, the judge is recapping all this. Obviously, this takes longer. And the judge says, okay, she says that she's the nicer of the two, and I agree with her. He says he's the saner of the two. I agree with him. Guardian ad litem says his mother should have placement. The custody placement evaluator says her father should have placement. But if these people are so interested in this family, where have they been for the 4 weeks we've been in trial? But this gentleman, you've been in the courtroom every day. And the judge points to the parent, the person in the gallery, the gentleman in the gallery, and he says, sir, what's your relationship to this family? From the bench, the judge begins to interview the guy in the gallery. And the guy says, I'm the godfather to the second child. Now, what the judge does is kind of like interviewing somebody for a job. What have you done before? What kind of training have you had? How much do you know about this? You know, what would you do with this? What would you do that? What are the names of the children? What are their ages? What grades are they in? Do you know their teachers? He knows 2 out of the 3 teachers. What's the oldest favorite subject? He happens to know that. What activities is the youngest one involved in? He knows that. Are you involved in anything with any of these children? Well, for one, he's the coach, and for the other, he's been teaching the other one how to play guitar. What's the favorite food for the oldest child? Macaroni and cheese. Do you know how to make it? Well, no, frankly, I've never made it, but it's in a box. How bad could that be? Okay, so he does, he's not like just trying to make himself into, Mr. Perfect. And the judge asks him this question. The judge says, sir, how would you feel about taking these children in and raising them? And the godfather in the gallery rises and he says, Your Honor, it would be the greatest privilege of my life. The gavel goes down, custody and placement are awarded to the godfather in the gallery, and both parents pay child support. And if you think you can hear a pin drop in here now, think how they felt. At that point, do you think they could have gotten together and said, okay, listen, let's do this? Sure they could have. You know they would have. They could have figured something else out besides that. But here's what the judge saw. It's like an invisible blood stain in the carpet. The judge saw these children as being stuck in here, and the only way they were going to get out was he physically had to get them out of that home. There had to be another option. And as soon as they said they couldn't agree, they handed control over to the state. So the state made the decision for them. Now, I'm not saying that's what will happen in your family. I'm not saying that at all. But that's just a very powerful example. By the way, that's not by far the weirdest case that I've ever heard of. It's just kind of an easy illustration of the fact that, when you hand control over the state, you never know what you're going to get, and you have no control. And you two are, by far, the best people to make those decisions. So I would encourage you to do so. So at this point, here's what I'd like you to do. I'd like you to rip off that survey, leave it back there on the table. The gentleman in the back is Terry Wilson, the phantom mediator, who is just here from his parental duties. So I'll say hello to Terry. He's the nice of the 2 mediators. And thank you very much, and I will see you at 3 o'clock on Wednesday.